Today's session is about the risk management. First of all, I'd like to thank Alicia from our insurance broker. She's here to give us a talk on the, kind of more focus on the professional liabilities. We've been working with her for the past 10 years, and let's just go around the table here, introduce ourselves to her.
Stuart Cook, structural engineer.
Travis Patel, civil engineer.
Gil Kabara, structural engineer.
Marwan Salhab, civil engineer.
Marco Canton, civil engineer.
Ben Cole, civil engineer.
Rick Rubin, I'm the principal in San Diego.
Okay. Are you structural, civil?
No, civil.
Civil?
Yeah.
Okay.
So you met Roy and Sylvia.
Ryan, yeah.
Okay, so I will use this. I will use this to short slide to introduce her before I bring her up. Do we know? I can use this keyboard probably.
Actually, separate.
Huh? No, you go through my slide first.
Oh, is that right?
Yeah. We'll bring her up one over there.
This is live recording.
Next one.
Yeah, go down. There you go.
Okay. So just a recap of last session on the business development. So we talked about a few topics last time, capture management. You recall the chart on the right where the efforts ought to be made before the RP shows up, and we'll be able to increase our success rate and also spend less efforts to capture projects. We'll also practice a little bit elevator speech. Each one of us did that. We stress that project manager is a seller-doer function in order for us to grow. Also, we run through the sales process from the RP, go, no-go, how do we prepare the proposal and go through the interview process, as you recall. And Roy, just similar to today, he went through some of the recent pursuits and also talk about the Expo 2 as a successful example. How do we go by to practice the capture management? So today's session is about risk management. So what the risk? What type of risk we're talking about? For our business, we are a high-risk business. As you can see on the right side of the picture, this is where the pedestrian bridge at Florida International University collapsed. So we've seen that. We oftentimes hear things like that. So we have similar high risk in our business as well. Professional liability address to that is how do we practice ourselves to mitigate the risk, where Alicia is going to spend some time. Another key risk for us is getting paid, where after all it's a business. We wanted not to do free work as much as we can. Oftentimes we cannot avoid that sometimes, but we want to get paid. We want to make sure that we don't risk of our financial positions. Other risks related to general liability, like somebody get hurt, somebody get sick, or whichever that is, which is less of a concern for our business. Employment risk is obviously related to employees. From an employee standpoint, there's a risk coming to any organization to work in terms of the stability, the security. From an employer standpoint, there's a risk associated with that too. We often hear there's claims of harassment.
You can say it both ways to make it smile.
Yeah, there's sort of risk that Sylvia deal with, not so much Alicia directly. There's a business risk too. Business risk from the point of how do we balance how aggressive we go out there to invest ourselves versus the return. All of that, which is the things that we need to really watch out for, so that we have the sustainability for the business. So today we're gonna mostly focus on the first one, the professional liability, which is most difficult for us to understand. We'll talk about a little bit after Alicia's presentation, other topics. After lunch, we're gonna do a little exercise that's where I intend to introduce you, Alicia. I will help you to introduce your personal background a little bit more of yourself. With that, let's just flip to her presentation.
Well, while Sylvia is helping with the IT part that I don't do well, I'll just give you a little bit of background. I am because I'm a little frugal on ordering new business cards, I am actually a managing partner at IOA Insurance Services, and I run our Aliso Viejo branch. I have been providing insurance and risk management to design firms like yours since 1986. And I've had the pleasure of insuring your firm since the end of 2007 when Peter first started the firm. So I'm happy to be here and enlighten you on a little bit more of professional liability. I know the topic is insurance risk management, so don't shoot the messenger. I know that insurance at best is a gray subject area, and I'll try to do my best to read through these slides, so please pardon me if I'm not giving a lot of eye contact. This presentation is actually one that was developed by RLI Insurance Company, who is one of your insurance carriers. They do bi-monthly webinars. So this actually comes out in an hour-long webinar that they provide. So what I'd like to do is take you through it. And the topic is actually pick one. Professional liability, general liability, both or neither. Because sometimes you're going to have clients out there or contractors out there who mix them up. And even internally, sometimes it's like, what are we talking about? You could have a conversation with one of your clients and you thought you knew what you were talking about and they've confused you. So with that said, let's go ahead and start.
All right, let's go this way here. Yeah.
Oh, okay. This is copyrighted material. That's an important thing for all of you as well, because your instruments of service are yours and they are copyrighted. So, okay. So as we get into the course description, as I was just alluding to, many clients and contractors confuse a design professional's obligations for professional liability and general liability. But the distinctions are important because the exposures, the insurance coverages, the premiums, and the deductible obligations are different. So whether it's in contracts, in project risk allocation, or in day-to-day project management, many clients and contractors confuse a design professional's obligations for professional liability and general liability. The distinctions are important because of those exposures, the coverage, the premium, and the deductible obligations, the differences in those. Most design professionals who perform scope of service largely based on industry standard contracts, services like conceptual design, design development, preparing construction documents, and observation of construction, your general liability, like Peter mentioned, your general liability exposure is usually very minimal. It's limited to unlikely events like visitors tripping and falling in your office, whereas professional liability is the biggest exposure that most design professionals face. If a design professional fails to design in accordance with the ordinary standard of care, the professional liability claim involves direct damages and possibly consequential damages, which can be severe. The rework, property damage, injuries, and lost revenue all have the potential to exceed the amount of your fee and possibly even exceed the construction value in extreme situations like the collapse we saw of the pedestrian bridge not too long ago. The insurance coverages are therefore also different. Professional liability insurance is a standalone coverage. Pollution liability coverage, in many cases, it is bundled in with professional liability, but in the majority of cases, even pollution liability will be the cause, at least in part, by negligent performance of the services. And that's where we really talk about professional liability, is we talk about the standard of care and your negligence in providing your professional services. For example, if a geotechnical engineer makes a boring that causes a pipe to burst, that still happened because the professional services being performed by that geotech. General liability, though, is often bundled with at least other and sometimes several other coverages. For RLI policyholders like yourselves, your general liability insurance is bundled with your property, hired and non-owned auto, and with that general liability, we call that a business owner's policy. Another difference between professional liability and general liability policies is that you have a deductible obligation that you have to pay first before your professional liability pays. With general liability, you don't have a deductible. So when we talk about these obligations, they are in themselves very different.
Can you explain some of the terms that you just mentioned? For example, what is the ordinary standard of care? What is the consequential damages? What does a deductible mean?
Okay.
Some of those basic terminologies.
Well, when you're talking about the ordinary standard of care, the ordinary standard of care is that which another civil and structural firm providing similar services in a similar area for a similar project would do. So if there's ever a situation where you're involved in a claim, usually what your side and the other side are going to do is get somebody who's a forensic expert and ask, what is the ordinary standard of care, and did PAC-REM adhere to that?
Do you have to do above ordinary standards?
You do not have to do above, and in fact, you should never agree to a higher standard of care, because your professional liability coverage covers you for the ordinary standard of care, that for which you are legally liable. My coined phrase a long time ago, you are a design professional, not a design perfectionist. Do not allow somebody to understand the expectations up here, yet they're paying you down here. And if they think those expectations are up here, they're paying you down here, this is what's going to happen in a claim. Remember that hourglass, because it's something you can think about and apply to a lot of the things that we talk about today.
So that's different from a different school vocabulary from what this is about versus QQC that we talk about. There are two different. Maybe you can help.
Well,
me with
the
that.
only thing I would say is the reason people end up in court is because there's always a debate about what standard of care means.
Correct.
And the expert we hire is going to possibly have a different definition in that he will have a different definition.
True.
About what the standard of care was. One's going to say it was met, one's going to say it wasn't met. So
And that's why communication from the start is very important. One of the things that I really liked on one of Peter's earlier slides was talking about the go, no-go on a project. That's really important. And the longer that you are in your field of expertise, you're going to start having this gut that, gosh, I remember this project from 3 years ago or 14 years ago. There's a lot of things that come into that, but really having a go, no-go, and a process for doing that is very helpful.
Particularly with the client, not just the project.
Correct.
Because some clients have no litigation history. They always solve their problems, work it out amicably. Others have a history. You probably don't want to work with people like that. Have some extraordinary compensation.
And if you're finding that in the contracting process where, when you're trying to sit down and negotiate so that there's a more reasonable contract, that you can agree to than the first one that came out of the chute, which is usually the one that's all lawyered up. If you're getting a lot of resistance before you're even working with them, imagine the kind of difficulty you'll have if something goes wrong. So that's really an important
In the context of this, are you going to talk about consequential damages and things like that?
a little bit.
So maybe we should
A little
just
bit.
Yeah, hold that.
Well, and
That's a different
consequential
concept for-
consequential damages. It's really that's economic damages. That what if you're doing the structural for a, I don't know, 500,000 square foot retail development that's supposed to open alongside some other big opening, and all the structural elements are all wrong, and it takes you 9 months to redesign. They lost 9 months of expected revenue. Believe me, there is an attorney and a CPA who can forecast out how much they lost, and that's what they're coming
Plus the
after you
interest
for.
that you pay
Plus
during
the
that
interest, yes.
Okay.
That's much other stuff.
So let me correct me if I interpret it incorrectly. Say let's say you build a pedestrian, this Florida pedestrian. That pedestrian bridge leads to a shopping. If this bridge got a collapse, not only the repair or reconstruction of the bridge is direct damage. However, the time delay, the revenue loss of the community would be considered as a consequential damage.
That could
Right.
be considered, because then you've got all those businesses that have a business interruption loss because of that collapse. And usually each one of them will be able to show, based on their financials, what their loss in monthly revenue is. So they're all going to be coming to the table.
So in a contract sense, it's important to look for those things. If that's in the language or not in the language, what that means.
So again, that goes back to the damages could be larger, definitely larger than your fee, and in extreme cases more than the construction value of the project. Peter asked, deductible. While we don't have deductibles typically on general liability policies, on professional liability policies, there is a deductible, and it's for each claim. So if you have 2 claims in a policy period and your deductible is $25,000, you could be paying $50,000 on top of your annual premium for those claims.
Right.
Okay. So,
If the
and
ceiling of the coverage does not, it's not enough to cover the damages, that's another thing, right?
correct. If your limits, and we'll get into this a little bit further along in the presentation, but with professional liability, not only are the damages that would be paid to other parties, to like your client or anybody that's saying you were negligent, part of the limit, but also the defense cost is part of the limit. So if you blow through your limit, if you exhaust that limit, anything over that is borne by the company.
Attorneys are very clever at knowing how much insurance each person has.
Yes,
So
and
it's-
usually
Usually they're trying to get
we
your insurance.
we have had several policy limits losses. Exactly. So they're very good at determining those figures.
It has to be
It's
disclosed,
part of
so
discovery up front. So, but let's,
Yeah.
are we,
Yeah.
okay.
Good. Thank you.
Let's see. Okay. So today we'll talk about some of the differences between general liability and professional liability, why it's important. If you ever work as a consultant to a contractor or design builder, it may be important for you to understand the difference. Contractors and design builders have a much bigger general liability exposure than design firms do. And the reason for that is they're not providing a professional service. Now, on the design builder, there's a little caveat for that because I do insure some design builders. They do have a design exposure with a construction exposure, which makes them even a more complicated risk and more costly on top of it. And then we talk about contractual obligations for professional liability and general liability are different. For example, let's say that part of your professional services for a particular project is to conduct face-to-face interviews with members of the public, perhaps to get their opinion on a proposed toll road, bike path, or community master plan. Whether you're interviewing the public in the streets, at their homes, in a public building like a school or a library, or at your office makes a big difference in terms of your general liability exposure. You can manage the risk by thinking it through and choosing the least risky environment, which might be the public library or public school or the library. Right, the park could be an issue. And then you're going to have to think through the contractual implications too. A smart city attorney might ask you for what's known as a split or a bifurcated indemnification, which has one section that requires you to indemnify the city for professional liability claims and the other for general liability claims. Really, that would be the best avenue. We don't see that a lot. So when we don't see that, we really have to look at your indemnification obligation from a professional standpoint. And with that, your professional liability carriers never provide an upfront defense to your client or any other party. Whereas your general liability, when they're named an additional insured, does provide an upfront defense to your client. Okay? So those are...
Understand indemnity?
Okay.
Yeah.
Quick
Yeah.
explanation.
Okay,
With that.
so indemnity. I know it's painful, Stuart. So indemnity, that's to make one whole again. So if you were negligent in providing a design and you damaged someone, that other party is looking to you to make them whole again. So that's why they are called indemnification agreements, so that up front you've got an agreement between yourselves and the client to make them whole in the event of your negligence. And I underline negligence because that must always be in an indemnity agreement, or it's much broader than your insurance. Okay? Okay. The last thing that we'll talk about today is how all of this kind of works together and how it plays out in the form of claims. We'll talk about some cases where the allegations pretty clearly relate to professional liability, cases where they seem to fall more clearly under general liability, and a few cases that are going to be a little bit more difficult to determine. So, when we look at risks for general liability insurance protects an insured from third-party claims arising from bodily injury, property damage, personal injury, and advertising injury. And if anybody has ever seen a certificate of insurance, you'll actually be able to read through it, and some of these things just jump right off the page. Typically, general liability policies exclude faulty workmanship and, I underscore, will not cover purely economic losses like lost revenues. Probably the most common general liability claims against design professionals involve trips and falls in their own offices by visiting clients, potential employees, vendors, or other visitors. Later on, we'll cover the difference between bodily injury and property damage arising out of professional services and bodily injury and property damage not arising out of professional services. It sounds simple in practice, but it actually is more complicated than it sounds. It's also important to note here that because the non-professional liability risk for a design firm are often quite low, insurers are often willing to add on other coverages. And that's the whole concept of a business owner's policy that includes your general liability coverage. Many people talk about general liability, but it's actually embedded within a business owner's policy. So sometimes it's confusing. Okay. Now we get into the risks of professional liability. What then are some of the most common causes of professional liability claims against design professionals? Again, think here the hourglass when you're thinking about some of the issues that I'm going to talk about here, because it's expectations versus what your services really are, and if they're not clearly understood, what could happen. So, unrealistic client expectations. In the process of selling your services, sometimes design professionals go too far. You oversell yourself, and the result is that the client is encouraged to believe that you are much better than you really are. The client isn't ready for your natural human limitations. So when you make an error of any kind, the client feels shortchanged. Don't let them think that you're a design perfectionist. Let them know that you are a design professional, and judgment is part of this. Professional judgment is part of this. You are human. Office standards. Anyone can make an error. Design professionals aren't perfect, but professional standards have to be maintained. Offices shouldn't take on assignments that are beyond the realistic capabilities and expertise of the firm's principals, available personnel, and their consultants. The office needs to be properly equipped, including all necessary research materials. The principals and technical staff need to continue with relevant professional education on an ongoing basis like this. The office needs to be organized to gather and maintain all necessary records and information for each project undertaken, including the client's program requirements, building and zoning code criteria, timekeeping, and accounting. Quality control, we were talking about that a little earlier. Probably the most effective safeguard in the avoidance of error is continually reviewing and checking your instruments of service. Senior personnel need to scrutinize the work of less experienced staff members. That means all of you need to have that extra set of eyes, that double check, that triple check. Failure to check and coordinate the instruments of service would be considered professional negligence, because the majority of design professionals normally check and double check their work. Agreeing on an appropriate fee. When the agreed fee is not enough to cover the necessary services, there could be economic pressure to reduce the quality of service, with the possibility of substandard professional work. Insufficient fee income isn't an ethically or legally acceptable excuse for performing defective or inadequate professional services. If a sufficient fee can't be obtained for performing the required scope of service, the project shouldn't be undertaken. And in a caveat to this also, it's important that when you are speccing your scope of service to also include what isn't, those services that are additional, that will cost the client an additional fee. They're not a part of your scope, so that when it does come up, and invariably it will come up, it's not a situation where it's contentious. You bring out the contract, oh, we'll be happy to do that, city of Long Beach. The fee for that service is X as articulated within our proposal dated this. Please sign this addendum and we'll be happy to get started. Too often, many firms miss the opportunity to charge that additional fee. Or sometimes they're so busy they're so involved in the project that they miss it. They wait a while, and then it's like, we'll just let it go. You can't do that, because you do that once, and it sets the expectations for the future. Okay, contractual insurance and indemnification requirements may be outdated, unattainable, expensive to meet, or unreasonable. But failing to meet them may have significant consequences for you. Peter, Roy, and Sylvia, how many times have you seen me write outdated, unattainable, unreasonable on a review of a contract? There is no perfect contract. If you stick to the industry standard contracts, the CJCDC, contracts like that, you're going to get much better results. But even they need to be tweaked. But when you're dealing with client-drafted contracts, I see insurance requirements from the 70s, the 80s, that are no longer attainable. They want endorsement edition dates of 1985. Well, there's been a lot of court adjudications that make those forms outdated because the insurance companies were giving away coverage. So there have been changes, but a lot of contract drafters have not updated their contracts. And there's a lot of firms out there that just sign them because they don't want to raise a stink. Well, it doesn't matter until it does. So if you've put yourself in a position where you've agreed to outdated, unattainable, or unreasonable requirements, your insurance policy that you have in force today, it's not going to change to cover your contract. You still have coverage. The policy prevails, not the contract. And there's a lot of contract drafters out there, and there are attorneys that really don't understand that point. But let me read from the slide. Okay. Contractual indemnification and insurance requirements may have a whole slew of problems, but in the eyes of most courts, arbitrators, and mediators, you, as educated professionals, have the ability to understand these issues and negotiate with your clients and walk away if your potential clients are unreasonable. I didn't know, I didn't understand, I couldn't afford it, or this client isn't reasonable are excuses that are rarely, if ever, accepted. Instead, breach of contract can have significant consequences, up to and including your termination from a project. Individuals may have consumer protection laws to hold up as defense, and ombudsmen and Better Business Bureaus to act on behalf of a consumer who's been wronged. But for anyone who's smart enough to earn a degree and start up a business, there are fewer protections you can count on. As long as your client can show there was a meeting of the minds, that there was an offer and an acceptance of that offer, that something of value, usually money, was given to you in return for your services, that you both negotiated in good faith, and there has been no violation of public policy, most people will adjudicate a claim. We'll start with the premise that you had a valid and binding contract. So even if you did sign something that's outdated, unattainable, unreasonable, that had those provisions in it, you're going to have to defend why you did that. And the word defend costs money. The thing that we haven't talked about when we've talked about claims yet, not only does it cost money, what else does it cost? Time. So, if you're out giving a deposition for 8 hours, what is the company billing? Zero. Zero for you that day. So many times you've got deductible, you've got the someone being out of the office and actually giving depositions or interrogatories. That time, how are you going to replace that time that we didn't get to bill? And it's usually not just one individual. Sylvia's going to be running around here like a chicken with her head cut off, getting all the contract documents together, getting all the correspondence together, because they're going to want it all. So remember that time. You guys need to be able to focus on billable hours. So, therefore, when you're looking at a contract and the insurance requirements look to you like legal mumbo jumbo, just don't sign them. Get some professional advice to help you navigate through it. And this I'll just kind of briefly talk about. Commitment to carrying insurance. Many times with professional liability, your clients are going to require that. Typically what we see is anywhere from 3 to 10 years. So especially if you've got a client that is requiring higher limits, not only do you have to think about it for that period of time, but for that 10 years after, usually after substantial completion, you've got to carry that limit for them. What's your profit margin? So, you've really got to weigh that on, is this something that's realistic to us? But one of the biggest things that you want to do is, if you are agreeing to carry those limits for that long for that particular client, that you do so at commercially affordable rates. Now that can get into a whole other discussion on what's commercially reasonable and affordable, but that's where, again, you look at who is your client. Were you able to have good conversation from the start? Do you have a dialogue with them? Are you all looking to get to that same place? A great project with lots of communication throughout. Those are the clients that, that will help you maintain that reasonableness. Okay. Contracts. This is where we're really talking about when you're looking sometimes in your contracts and they're requiring, let's say that you're the prime and you've hired mechanical engineers to come in and do some part of the scope of a project that you've taken on. Sometimes you'll see a provision in your contract that as a prime consultant, not only does the contract require you to maintain your own insurance, you must ensure that your consultants maintain insurance too. Well, the word insure basically sets you up for a breach of contract yourself if you didn't ensure that your consultants maintained insurance. The better term to use is you'll require them to maintain insurance. And then if they don't maintain it, you've got a breach of contract against them. But you're not putting yourself in a position where you're taking on that client obligation for not ensuring that subconsultant maintained insurance. Okay, contractual liability. This is, I'll spend a little bit more time on this because this is a widely misunderstood. You may have heard language out there, blanket contractual liability to cover all of the liability assumed by the consultant in the contract. That's not how insurance policies work. So, with both professional liability and general liability, this issue is the same. Insurance companies don't cover liability that you assume in a contract unless that liability also exists in the absence of a contract. If you're legally liable for it, okay. But it's like when Peter was talking about a higher standard of care. If you've taken on a higher standard of care, that part's on you. That may not be your legal obligation. That's not your legal obligation to take on a higher standard of care. Many clients, either owners or contractors, get confused because general liability insurance does have coverage for what's known as an insured contract. But if you read the policy definition of an insured contract, it's pretty narrow. Insured contracts include things like leases, sidetrack agreements, easements, things like that. if you keep in mind that general liability insurance specifically excludes coverage for claims arising out of professional services, then it makes sense that a professional service agreement is not an insured contract under general liability. The reason for the contractual liability exclusion in both professional and general liability policies is clear. If carriers tried to assume all of the risks that you could assume under all of your contracts, coverage would either become prohibitively expensive or not available at all. Therefore, the coverage that exists before any liability that you might assume under contract is the same coverage that exists regardless of the liability that you ultimately assume under contract, that for which you are legally liable if there was no contract. And this is why we spend so much time reviewing indemnity agreements. This is one of the most common places to assume contractual liability for which there is no coverage.
So contractual liability, how is that came into the language? In what kind of form? It has different clause to it, or how?
Well,
how it appears?
So a lot of times it's within your insurance requirements. You'll see it on both the general liability and the professional liability, where in the text let me back up. It would be much easier if all of your clients, when they asked you for insurance, would stick to the type of policy, the coverage, and the limits, instead of trying to say what your policy does, because most of them don't know, and most of their attorneys don't know. And that's why it's written in ways that put you in breach the minute you sign it, because it's outdated, not available, unreasonable, or they're asking you for contractor coverage. You're not a contractor. So you'll see it in general liability and professional liability, and many times they'll just spell it out. Your policy will include contractual liability that will include all the obligations that you assume within the indemnification. That's not what your policies do. They only cover you for your legal liability. So when you take on that additional exposure, you're going to have to talk to Peter and Roy about where that is going to come from, because it's not going to come from your insurance companies. Primary non-contributory. Typically, if we have named someone as an additional insured, all of your clients require within the general liability that they be named additional insured. And what that does is it provides them a defense as well as your limits. One of the differences between professional liability and general liability is that with a general liability policy, your defense is outside your limits. Whereas with professional liability, your defense is within your limits. So when you name someone as an additional insured and you provide them your limits plus defense, that is what could go against the firm if there was a claim. So you want to be very careful that you are only allowing additional insured status to your clients and the project owner, not their bucket of extraneous third parties for whom you have no idea who they are or how they're in any way connected with the services that you're providing. Primary and non-contributory goes along with that additional insured. It basically says, it's basically your client saying, we want to make sure that your general liability covers us until it's exhausted and that ours doesn't come into play until you have no more limits left. So you are saying, we're going to take care of everything.
Okay, can you explain a little bit more on addition assured, the concept, what that means in a plain English?
Okay. It basically means that that Pac Rim is standing in the shoes of the client and providing general liability coverage to the client for any actions of Pac Rim or any of Pac Rim's subconsultants. So if there's a third party that comes against your client and says something at a project, and again, we have to go back to, this is bodily injury and property damage. So let's say one of your structural engineers drives your truck through a job site and runs over a construction worker and ends up going through another building. Well, you've got both bodily injury and property damage. If that client was an additional insured, he's going to be sued by the construction worker's contracting company, the firm, and is going to basically tender the defense to you for the injury to his construction worker. And that building that's been damaged, they're going to look to Pac Rim to cover the damages to that building. And they're going to say, we're not turning it into our insurance company because Pac Rim is handling that. Your insurance company would pay the damages, indemnify them for the workers' comp claim against the construction worker, and also the damages to the building. And you would be providing a defense because there would probably be defense costs along with it on both of those
So
issues.
in those chain of events, let me correct me if I'm wrong. So Pac Rim will be the insured.
Correct.
The city will be additionally insured,
Correct.
right? So that's how it resides.
Correct.
And
they
the
would
worker
be your
or the property
client.
owner will be the one that suing. to
More
recover.
than
The
likely.
client is always going to be the additional insured.
Correct. The
So
client
requiring that of us to
and
insure them.
right, your client, and depending upon who your client, the project owner as well. And those are reasonable to be named additional insured because you're actually providing a service to them. And they can be vicariously liable for your actions or inactions. So that's what your general liability policy is covering. But again, not based on your professional services. It did not take a licensed engineer to run over someone or to hit the side of a building. Okay? Now, I'm going to, I'm actually, since, gosh,
Want to go faster?
you know, I kind of want to get to, if I can get to the end and kind of go over claim scenarios. I don't know if we've actually done enough to where it makes sense, and I'm so sorry that but you've had some good questions. Okay, the claims end. How do these really play out? Let's see if we can get through this. Claim scenario number 1. A civil engineer at a construction site gets frustrated with the mud surrounding their trailer. He trudges around the site, finds a hose, goes back to the trailer, and begins hosing it down. He leaves this task before completing it to take a phone call. A bicycle messenger making a delivery to the site travels over the hose at an accelerated speed, is thrown from the bike, and suffers numerous broken bones and other serious injuries. Under which policy is this claim covered? What do you think?
Sounds like general liability.
Very good. You don't have to be an engineer to hose down the area and leave the hose out, and you know he's basically made an unsafe site condition based on what he did, but that didn't have to do anything with him being a licensed engineer. Let's go to the second one. let's see. You know what? We didn't really talk about products, so let's go to the last one. Claim scenario 4. A structural engineer is called on an emergency basis to determine the structural integrity of a building that has been damaged. Unknown to the engineer, there has been damage to an underground gas line, which is leaking gas into the building. The engineer does not warn the building occupants or the people in adjacent buildings because he is unaware of the harm. After the engineer leaves, a fire breaks out. A number of people are seriously injured. Several parties make a claim against the engineer for failure to warn of unsafe conditions that caused the fire. Under which policy is this claim covered?
Both. First,
This one was a little less clear-cut than the previous example. Should the structural engineer be aware of damage to an underground gas line? It really, maybe not, depending on how much time he spends on the site, what his scope is, and how much he's being paid to make his assessment. And kind of getting back to what we were talking about earlier is the experts. It's what degree, what should he have been doing, what is the standard of care for that. It would take specialized, if it would take specialized skill or training to become aware of the damaged gas line, then it's probably a professional liability claim. But if any person of average intelligence would have noticed the damage and the potential harm, then it's probably a general liability claim. So often what happens in these scenarios is that you report the claim to both your carriers and then let them assess the allegations and determine what happens on any of the damage to either prove that it was based on your negligence or that there was no negligence involved. And I'm getting Sylvia's giving me the sign. Oh, you had a question.
You said professional liability is what you're legally liable for. A structural engineer is not legally liable for a gas line underneath the ground, right?
Yeah, I guess
Well-
especially this question is the structural integrity. The gas
well-
line is not.
Right,
Into the ground, they're not looking
and that's why they were talking about what is your scope of service. It is tricky. This shows how there can be multiple things going on, so that even if you were called out to look at the structural integrity of something and there was something else altogether going on, you could be called into, there could be allegations against you for not, but you didn't even, that was not part of your scope. So again, it doesn't necessarily mean that you're not going to get sued for something. If you are sued for it, you need to defend yourself. And the best way in a situation like this, where the allegations are not clear, is report it to both your professional and your general liability carrier to make certain that the allegations and the actual damages are reviewed under both policies to make sure.
Can you cover a little bit on waivers subrogation?
Yes. Okay.
That's a
So.
hard concept for us to understand.
And see, a lot of times when we go over waiver of subrogation, there is, let me go back. Okay. Waiver of subrogation. Since the term is not used every day, let's define it. Subrogation is the right for an insurer to pursue a third party that caused an insurance loss to the insured. Subrogation is the right for an insurer to pursue a third party that caused an insurance loss to the insured. This is done to recover some or all of the amount of the claim already paid on behalf of the insured. Let's say that a claim is made against you, but it's complicated, kind of like the last one that we just looked at, and not completely straightforward. If during the course of the claim we see an opportunity to settle it, we, being the insurance company, we might recommend that we do so. But when we do this, part of our strategy might also be to seek recovery from some other responsible party. So who are all the proximate causes of damage? If the other party is your client and you've contractually waived that right to recovery, then you're stuck with a loss on your loss run, which may impact your next renewal. So, while the insurance company said they will agree to an upfront contractual waiver of mutual subrogation rights, and the insurance companies agree to it, you need to know what that means. It's not always the best thing to do, but you know what? The reality of today, you're not going to get away from it. They want that on your general liability, they want that on your auto liability, they want that on your workers' comp, and they want it on your professional liability. So the property waivers that you see out there, that each party waives their rights against each other for those things that are covered by property insurance, that's really a non-issue. Those are okay. The ones where it's the liability, you do have to be careful. You do have to make sure that you're limiting those to the client and perhaps the project owner. But again, it's difficult to say no because we don't find anybody that can get around those. It's not a good thing. I hate them. It's not putting responsibility where it lies. And that's what everyone has a hard time with. Any other questions? I know that's not always a good answer.
Convoluted.
It is convoluted.
It's a subject that has great implications.
It does. It does. And I'll tell you the great implications that it has. We did have a client who the prime that they were consulting with did not obtain insurance correctly from our insured who was a sub. Meaning they didn't ask for additional insured status or get the primary non-contributory or the waivers. There was a construction worker that was injured and the prime and our sub were implicated. The prime got nailed, our sub got off because the prime took the hit for not ensuring that they had the correct coverage. Unfortunately, OSHA came in around the back door though and assessed both the prime and our client for the injury to the construction worker, and it somehow was that some scaffolding was moved, and the construction worker fell and broke both of his legs when he walked on the scaffolding that was not re-secured after the engineers had moved the equipment, the scaffolding equipment. So while my client got off on the insurance portion, he got fined pretty severely from OSHA.
Okay. Do we want to have her maybe run through the suburban water comments? Maybe that's an application we can walk through that.
Yeah, I'm happy to do that.
Very quick.
Uh-huh.
Is there anything else you want to kind of help us to look at it?
Let's see. And what Peter's talking about, this is actually your suburban water contract, and these are kind of my notes.
So we can walk through this one.
And And really, when I go through this, some of this is just, you know, grammatics. So is it, you know, in my life, I'm really just trying to get everybody out there up on the same speed, and kind of if they looked at their certificates of insurance, they could match, you know, language, terminology. So it's just in an effort to help get everybody up to speed. Okay, so here is, when they talk about, if you'll look at C, commercial general liability insurance covering claims for injuries to members of the public or damage to property of others arising out of covered negligent act or omission of consultant or any of its employees. You'll notice I crossed out the word agents, subcontractors, and per project. The word agents, it's one of those third-party extraneous words that could be anybody. It could be somebody's drunk brother-in-law. It could be somebody's attorney. We don't know who it is. Why do you owe them a duty? You do not. Get it out. And you don't have subcontractors. You have subconsultants. In this, we've been talking about the standard of care for design professionals, and it's that of negligence. When we talk about contractors, they're held to a strict liability standard, which means pretty much anything they do, they're liable for. That's not what a design professional is held to. So we want to make certain that our clients understand that you're a consultant, and any of your subs are also consultants, not contractors. You provide professional services, not work. Maybe a simple concept, but if you ever have to go to court, it's important that somebody, because of what you've done, be able to come in and explain how you're different than a contractor. You'll notice I crossed out D because it said contractual liability insurance in amount sufficient to cover consultants' indemnity obligations and not less than $1 million for each occurrence in the aggregate. My comment, contractual liability coverage is not broad enough to cover the extent of indemnity obligation. Contractual liability is included only to the extent liability would have existed in the absence of a contract. This is industry standard, but I will guarantee you, most of your clients will say, I've never heard this. Everybody does. No, they don't. And if they think they're getting it, they're sorely misunderstanding the coverage. And somebody is not taking the time to articulate that it's not there. It's the insurance policy that's a contract between your firm and the insurance company that prevails as to how coverage actually applies, not your client's insurance requirements.
So what's the consequence if we leave item D intact? What it means to Catherine?
Then that means you basically told your client that your general liability coverage covers your indemnity obligations up to an amount of $1 million. And it only covers your firm for that which you would be legally liable without a contract.
So realistically, Catherine will be liable for $1 million because the policy doesn't cover it.
Correct. You could be. What are their allegations? Here they ask for coverages for products and completed operations, and professional liability errors and omissions must be project specific and shall be maintained for a period of at least 3 years after acceptance of completed work. So there's that period of time, but also they're saying project specific. Both your general liability, where products and completed operations are covered under, and your professional liability policies cover all of your firm's civil and structural services on all projects, not just that project. They're trying to say that the limits for those two coverages are exclusive to their project. They are not. Okay.
Pollution liability. What pollution liability covers?
Okay. Pollution liability, this is where you have to articulate with the client what is it that they're looking for. If they're looking for like a contractor's pollution that gives broader coverage, want to be named as an additional insured, you don't have that. You have pollution incident included within your professional liability coverage, that if it has anything to do, if there's an allegation of pollution based on your negligence, your policy is going to respond. But many times your client doesn't understand this, so they'll just come back and say, oh, we'll take what's in your policy. Or, kind of like with the Port of Long Beach on the terminal, they said, no, we do want the contractor's pollution coverage. So when it's unclear, as this is, we would ask that you confirm what it is they're looking for. But 90% of the time, they don't know. And they'll usually just accept what you have. Okay, umbrella liability. Okay. Umbrella liability with policy limits of not less than $3 million, each occurrence an annual aggregate as excess over general liability, product liability, completed operations liability. They go on to want it to go over your professional liability, pollution liability, errors and omissions. There's a disconnect many times with clients. Sometimes they'll ask for errors and omissions, or they'll ask for professional liability coverage and errors and omissions.
They're the same, right?
They're the same. It's synonymous. It's technically professional liability, which covers your errors and omissions. So it can be very confusing. But there's only one policy. So in this respect, they seem to their terminology almost looks at it as two. An umbrella liability policy is basically just like what it says, umbrella. It sits as an excess coverage over your general liability limits, your auto liability limits, and the employer's liability limits of your workers' compensation policy. And it's over the products because that's part of your general liability coverage. It does not sit excess of a professional liability policy. Professional liability policy limits can only be increased via the professional liability policy, or if we increase for a specific project. So again, it's just unsophisticated clients that have cut and paste, and half the time they don't even really understand what they're asking for. Okay, and so in I, Suburban will be named as an additional insured with respect to consultants' liabilities hereunder in insurance coverage identified above in items B and C. So we've got, So B is your commercial auto, which that's not a problem. We can name them an additional insured on that. C is your general liability. Not a problem. But when we get into, and all carriers will respond to Suburban on a primary basis. No, it's going to be for B and C only. That primary and non-contributory goes along with the additional insured. On your workers' compensation, the sole remedy for an injury to any of your employees is your workers' compensation. So your workers' compensation is not going to apply on a primary and non-contributory basis to anybody else, except if you have a waiver of subrogation, which you do a lot, so I know it just makes things, but they will not provide a primary non-contributory language, but they will let you agree to waive your subrogation rights. So I know it's gray at best. And then with your professional liability is never going to be primary to anyone else. That is your coverage only. And even when when you may have situations where you've had to take an indemnity agreement, there was a real opportunity there, and you agreed to the upfront defense that's in that indemnity that's not going to be happening on your policy, even then, you've agreed to it. Your firm has agreed to it. Your insurance company is still not primary to them, and it's not going to defend them up front, even though you've agreed to it.
So additional insured means you're covering Suburban in this case?
Correct.
For B and C.
Correct. So for the general liability and the auto liability, if they're sued for anything having to do with anything and anywhere you've been on the project, you're providing them a defense and a probable indemnity.
So item J, you didn't ask or you didn't comment on item J.
On J, all policies shall be endorsed with waiver of subrogation in favor of Suburban. And my comment there was no endorsements are provided for excess or professional liability. So basically, while the waiver is acceptable under the general liability, the auto liability, and the workers' comp, there is a waiver embedded within your excess policy, because your excess policy follows your general liability, auto liability, and employer liability policy forms. The professional liability are still on the excess, but the excess does not have a endorsement. It's just part of the policy.
Right.
And the professional liability, while there is a waiver embedded in the policy, there is no endorsement. Does that make sense?
I'm more confused.
Well, and part of the confusion is that there's no, when you get into the AIA or the CJCDC documents, they're industry standard documents. When you work with private clients who have their own attorney-drafted professional service agreements, usually no two are alike. So how are the contracts of 100 of your private clients ever going to mirror your policies? They're not. And what we try to do is kind of give you some recommendation on changes so that it more mirrors the language and the intent of your policies, so that you've provided a more reasonable picture of how your insurance is going to respond in the event of a claim. You know, one of the things that we really didn't talk about, and actually they did a pretty good job, because actually Suburban has updated their contracts since the way past ones that we had reviewed. That in 2010, gosh, I'm an insurance geek. Okay, in 2010, Accord, which is it's a collaboration of many insurance companies that put together standard documents that your certificate of insurance is provided to all your clients. It's called an Accord 25, Certificate of Liability Insurance. They changed the cancellation language within the certificate of insurance so that only the first named insured, which would be Pac Rim, receives notice of cancellation from its insurance company. In the past, your clients all wanted the insurance companies to send them notice of cancellation. Well, this was a big failure on the part of the entire insurance industry, and I'm embarrassed to say that I was a part of it. I had written assurance from each of the insurance companies that I worked with that I used to cross out what they called the "will try to send it" to make it say that they will. But we were all in violation of federal copyright laws by changing the Accord certificate. So in 2010, they changed it on everybody and said, no, what you were doing is not going to be done. The insurance companies can't possibly send notice of cancellation to all of these folks. They're not going to do it. It goes to the insured. That's it. End of story. We still see language saying that they have to get it directly from the insurance company. So we do spend a lot of time trying to educate people that this 2010 change needs to be, adhered to. So, but Suburban had changed theirs. A lot of times you'll see that your clients want copies of your policies. We don't recommend that unless you're legally compelled to do so. And the reason that we don't recommend that is, for one, under your professional liability, your applications are a part of your policies. And there's a lot of sensitive, confidential information that, how do you know how your information is going to be treated? What are their privacy policies with respect to that? If you send it to the city, is that something that somebody can go in and say, hey, do you by any chance have a copy of so-and-so's policies? If you're sued, it's part of discovery. They'll get it then when they need it. But for business partners that are contracting to work together, there has to be, they're relying on you to provide a professional service over time. They should rely on you to be working with insurance professionals that are going to put forth honest information on a certificate of insurance. And that's why we say don't do that. Okay.
I have a general question.
Yes.
I have done this a lot in the past. When I had someone, an attorney or somebody, look at a contract, I asked them to flag showstoppers versus, you can make this change. We prefer to have it our way, but it's okay the way it is. But these are showstoppers. Got to get this changed. Do you make that distinction when you provide this? Because 99% of clients that see that are already in a reactive mode, and they don't want to agree to a large portion of it.
Right.
And they're not going to.
And typically, that's something that I think is much easier for an attorney to do, because commenting from an insurance standpoint, I'm just trying to say what we're trying to do is show how the language and what's being requested is not industry standard with how insurance policies are written.
Rephrase it.
I know exactly what you're saying.
Can you flag things that make it uninsurable versus got to have this because it's uninsurable if we don't make this change versus it's not standard, but you're still insurable with it. Possibly. Because what happens is now they come back and they have a whole bunch of questions. So are you doing another round like that, or what I try to do is get it where in my hands I can make most of those adjustments.
Right, I understand.
Try for them, but otherwise it goes back and forth. Some clients get very irritated when the back and forth continues endlessly.
Well, and I see what he's saying, because what we typically kind of hear a lot of is many times this is put in a project manager's hand on your client side.
Right.
And really the irritation is that they don't understand.
True.
And they don't like doing it.
Right.
And they feel that it's really not their part, that you should just sign it. So
Somebody else signed already while you're not signing it.
That's true.
all the time. Now, what we've found, if you can get through to risk management, that's a different scenario.
Depends on the company.
Well,
I've
it
seen
does.
It'd be worse at that level.
Really?
The guy was just hard on it. I had an attorney come to a meeting with me. It was with a developer, and the risk manager and the heads of the company were all in it. The risk manager was absolute about not changing these, and our attorney was very good. You probably know him. He's an Orange County attorney. Bill Walker. You know Bill?
No.
Brian Walker. But anyway, he presented to them this case about it's in your best interest. I mean, you want us to have insurance. The
Absolutely.
things you're putting forth are uninsurable, and so the things you're asking for are actually working against what you want. And then I think it was the vice president or chief operating officer, like, wait a minute, would say that again? And then he looks at his risk manager and he says, back to our guy, can you draft the agreement the way you would like it? Because that struck a chord about
Well, I'll
wanting us to be insured.
And that's a very good point. In fact, it was Kelly Silk at Suburban Water that back several years ago, the first time I went through a review, she actually called me and asked if she needed to pay me to change their contract with some of the comments that I had made, because she was embarrassed that their language was not up to current insurance. And I said, no, feel free. No, I'm the lowest paid attorney out there. But you're the attorney,
Yeah.
so you're welcome. You're welcome to take those, and
Yeah.
and I would encourage anybody that called to
Yeah.
do the same. So it's just really it's trying to get your contract closer to your insurance so that there's not as many. You're not defending why it's not the same.
Yeah, right, okay.
So, and that's, some of the adverse things, I've almost found that in dealing with either project managers or even some of the risk management folks, the angriness was more from they didn't understand.
Oh, yeah.
The people that actually do understand the issues are the ones that are actually the most reasonable.
Yes, they don't understand, or like you said, the project manager was like, God, I gave you this project, and now you're delaying it.
Right.
They have a
Right.
very short view of it.
Because, I'm sorry, under the gun, that's what.
Yeah.
Well, exactly. And, if it's not your, imagine all of you guys having to go through this with somebody, like with your subconsultants. What are you going to do? Okay, so these.
This is last.
Now we get where the rubber hits the road.
This is the indemnification. So, as we go through, as part of the consideration for this agreement, consultant for itself and its successors and assigns, you know what? It needs to be in plain English. If you have successors and assigns, you're not going to be here.
Yeah.
So let's cut to the chase and let's talk about who's agreeing to do what. The KISS method. Keep it simple, sweetheart, not the other one. Agrees to indemnify and hold harmless Suburban and its officers, directors, representatives, and agents. We don't know who those are. Employees is fine. From every actual loss. No. From loss, damage, injury, reasonable expense, judgment or liability, not of every kind or characteristic, whether in contract, tort, or you've got really good eyes, or otherwise, which arises directly or indirectly from consultants. And I crossed out willful, intentional, and reckless. Now, maybe those are reasonable, but your insurance is not going to cover them, okay? So I don't typically know engineers that go out there and are intentional or willfully reckless. Usually, it truly is negligence. So that's what your professional liability policy is going to cover, is your negligent act or omission in the rendering or the failure to render your professional service. So, and they go on to say whether active, passive, or gross. No, it's, use all of the adjectives of every which way. They need to be out of there. So, negligent acts or omissions related to this agreement.
And
actually, you'll see where I pulled in after judgment or liability, to the extent damages are caused by the consultant's negligent acts or omissions related to this agreement. So the negligence has to be it's the extent of the damages that are based on your negligence. So you're not paying, when you've got a client that wants you to, except for their sole negligence, no. Because that means they could be, you don't want to be paying for their negligence if they're 99% negligent. Sole means 100%. This indemnity and hold harmless agreement will apply whether such negligent acts or omissions are conducted by consultant or any of its subconsultants, or consultant or anyone for whom consultant is legally liable. You'll notice I added the last sentence, a duty to defend is expressly excluded and not a part of this contractual indemnification, because when we reviewed this was back in 2016, so after the CH2M Hill and the Weather Shield before it issue, even if the word defend wasn't in there, the courts were interpreting indemnification as defense, an upfront defense, even if you weren't negligent. So we still put them in after the, SB 496, where we've clarified the duty to defend a bit, but it's still not, it still has a lot to be, it still doesn't perfect design firms enough.
Has the client responded to this?
Yeah, about on this one we're going through it, but my question is similar. Is this last sentence been accepted
I've had
across the board?
I've had a lot of insureds that have been successful in getting it accepted.
That's hit and miss. But all the changes are hit and miss. You have to, it's
Right.
a negotiation.
Right. Well,
And then weighing your risk about what's...
exactly, and it's also, what type of a relationship do you have with that client?
I'm an expert witness now on a case, and I would say I'm primarily an expert witness because of that last issue, the duty to defend. It's a developer. There's a road that has moved over years. It's got a lot of cracks and stuff in it, and it's pretty clear to me from all the presentations I've seen that it's a geotech issue, but it's not as drastic as the city's consultants have made out, and the city's starting to realize that now. And I'm looking at the engineering firm that I'm the expert for, and I'm going, there's stuff, like there's settlement, but all the settlement for their stuff is right around the curve inlets. So it's pretty clearly local compaction, around the structure, because you see the dip there, and then you don't see it anywhere else. And some of the ground movement has gone one way and the back the other, which tells you it's not just sliding away. There's just some settlement activities, and it looks pretty stable now. And so I'm going, I'm not seeing it, to the attorney, I'm not seeing the big issue here with these guys. And he goes, the big issue is the developer sitting over there who's got all this responsibility, and they have a duty, they have an indemnification, the duty to defend, and they're stuck in this thing. And that could be huge. So it's because of pieces of paper like this.
Yeah, and so, that's why even, on a lot of these, are you going to have a claim? Maybe, maybe not. But it's maybe not if, it's when. And if your practice includes always doing your best to negotiate the most reasonable indemnity terms, you're going to spend a lot less in defense if it's pretty straightforward and you're only exposed to damages to the extent caused by your negligence.
Do you have anything in here about limited liability?
Liability. No, not in this presentation. But limitation of liability is great if you can get it You know, a lot of times your clients want to make it, you know, will even tell you that that even your insurance limits don't limit your liability.
Yeah.
So looking at your professional liability limits, general liability limits, you are not limiting your liability at all.
A few years ago, it used to be.
Well, but you would almost think with everybody, you know, we need to get back into the position where they're taking the limitations of liability on a greater course. But what I'd like to see is even there are some clients that have been able to limit it to their insurance limits.
Yeah.
But what I'd like to see even tighter to that is available insurance proceeds. What if you already have a claim?
Yeah.
So if you've got something else, and you know, while knock on wood, the most claims I've ever had a firm have in any single policy period is 6.
That's quite a
I did have one firm that had policy limits losses 2 years apart, and it was just like, so you really got to be careful about that. And especially if you can, you know, the $50,000 limitation of liability that's been out there for forever, in some cases on some of your large projects, I think the courts would look at that and it's not reasonable. But if you could limit it to your fee,
That's what I had written in 50,000
Yeah.
or
the
amount
fee,
of the
whichever is greater. And that's reasonable. But if they're going for the insurance limits, get it to available insurance proceeds and not limits just in case.
May also introduce this language if we can
Yeah.
get it.
Better to try.
Yeah, can hurt to try. Yeah. Just find some of those language to us.
The development contracts have gotten tougher over the years.
You know who actually bifurcated their indemnity and even in a conversation, the Olson Company, Caesar, is it Caesar?
I had worked with them in the past. The Olson.
And actually, I got on the phone with him, the attorney for the Olson companies, and he was complaining to me that it had been their outside counsel that was so combative with their consultants. And he goes, I kept going, you know, to our president and CEO to say we need to be partners with our consultants, and we know how their insurance works. We've got too many brokers that keep coming back, and we just keep telling them all, we've never heard this before. He goes, it's a crock because I've talked to some of them multiple times. He goes, we're posers. And in that conversation, he changed our client's indemnity agreement, their insurance, and I said, okay, Caesar, you know I'm not letting go with this. I'm going for this. He goes, let them all know. We're a kinder, gentler Olson company, and they've stuck to that. So, you know, it's getting to the right people, and I've said to a few of them. Now, it doesn't go over well because some of the attorneys don't particularly like it, and they try to tell me that they're going to report me to the bar for practicing law, which I'm not doing. But it's like, why are you telling your client to have these insurance requirements when this is going to come out? This is going to come out of the pockets of my insured. You're not going to an insurance company, so this is negligence on your part, and they usually don't like that. So,
Okay.
but
I think we got a lot out of this session. So let's extend our appreciation to Alicia. Thank you for the presentation.
you're very welcome.
So I had a couple of points on the board here. More or less just a talk of free discussions, and if anything we want to throw on the table to chew on. But then the risk is a real thing, you know. Ricky has been to the court in some kind of fashion. I've been to court in some kind of fashion. Depends on which side of the court you're on. You could walk out in a different feelings. I was in the losing side of the court, so it was not a really pleasant experience. On a professional insurance side, I think we kind of need to do a little bit more, make sure we do the due diligence as well during the contracting phase, where Sylvia and I are working together, make sure all the contracts pass through to some process. At least we look at it, like what Rick says, PMs need to look at it, look for those clauses and language and the insurance limits and what we're supposed to be liable for, and then pass it through the system. At least we go through some sort of a decision process. Even with all of that, we still run into problems that it comes in different fashions. Every case is so unexpected and a surprise to everybody. Metro Blue Line Duck Bank, that's one example I was wanting to talk about. We were providing the duck bank replacement design. So during our negotiation, Metro decided to remove our scope of work in terms of electrical and system engineering. We had a sub P2S on board. Because the budget was too much, they decided to reduce our scope. So we went through our design, and the Metro is supposed to be picking that up, the electrical system engineering, but they basically didn't do anything. We kept asking for comments from them. They dragged their feet, and in the end, they said, we don't have any comments. So we went ahead to complete our final P&E, went out the bid. So when bid finished, somebody else at the Metro started planning to build this. Now they're getting the operation people involved and their system people involved, and they're saying, no, this is not going to work, because my control house is supposed to cut into one of the manholes. You don't have any connections. How do I make that happen? So sure enough, we look at it. There is a as-built drawing showing an electrical connection to one of the old manholes, and we didn't really realize that, partially because they didn't really step up and tell us. If they told us at that time, we would have implemented those things and take care of it. Now the contractual implication is, now they wanted us to do it as part of the error and omission. They say, you put out a product that is not going to work. It's part of an error and omission. So no, it's not a part of our error and omission. You took our scope. How do I know? So we're into this fight discussions. We say no, they say yes. We say no, they say yes. Nobody is going to budge. They make their claims. We make our arguments. In the end of the day, I had a long meetings in face-to-face with the Metro, and they kind of each back away a little bit in admitting fault in mutual a little bit. And we're supposed to revise our cost change order proposal today so that we can come to a term. They already made it clear to me, we're not going to approve, all of the budget that you first came in. You have to reduce your cost. So that's how it's going to be most likely ended up with. So what's my point? I don't know what's my point in this context. My point that sometimes it's not a black and white, first of all. Secondly, even though there is a language in there, they may in the project management level, they may not be acknowledged, because you're arguing both sides of the story. The client side never wanted to acknowledge your side of the story, vice versa, right? We're arguing our side of the story. And nobody wants to elevate to the legal claim level yet. I mean, certainly we don't want to do that. I don't think the client wants to do that either.
But this is a civil contract, only civil engineering.
Yeah.
Okay, so considering that on the long run they're going to wire all those manholes and those conduits, it means that in terms of use, there's going to be an electrical engineer who's going to do all the design.
But we're missing a piece of the duct bank. Because this manhole is here, we build a new alignment with a new manhole here. Used to be a connection laterally coming to the existing manhole, and that connection needs to continue to here, or where alignment needs to join the existing manhole. You see there's a little gap?
Yeah, I understand, but the point that I'm trying to make is maybe we should have engaged an electrical engineer.
We had in our proposal.
He did, and they told him to remove it.
Yeah.
The P2S, and they were engaged and they said to remove it.
At the negotiation, contract negotiation, they remove that.
I know that this is the point that I'm trying to make. Maybe we should have
Anyways, you're saying.
Anyways, because you really want to know if this works, you know. I mean, we're doing the civil work and ducting and this, concrete and this and that, but then in terms of functionality, we don't know.
Yeah, we were counting on Metro to do that. That's spelled out. Yeah, I think that's the hindsight.
But I think it ties into something Alicia said earlier. It's not just what you're going to do, but when you remove that scope, then you maybe need to articulate what you're not going to do and what you expect somebody else to do.
Yeah, that's articulated.
In there.
Yeah, that's articulated.
Expect so-and-so.
Yeah.
And they're not right with that.
Yeah, they're not. They're saying you're supposed to do duct bank. You know, I'm missing a piece of duct bank. This is your fault. Whereas we didn't know we missed a piece of duct bank. You never told us if we need a piece of duct. And their counter argument is, look, the as-built plan shows there's a cable connection to this manhole. If you were reading the as-built, you would have asked the question. I mean, we didn't ask the question. That's where the gray area comes in.
Don't let them see our core values. Surpass ordinary.
Okay, so I guess the point is that there's some technical stuff. There's some contracts that they all kind of mush together, and sometimes it's very hard to see clearly out of it.
You know, one other thing we didn't talk about in terms of payment terms. So, you know, there's clauses in there about payment. We want to make sure that the payment terms are fair for us as well.
Yeah, that's where my next one kind of related to. So Terminal Island project is another case where is interesting scenario is where we have a team. We have two big consultants with us, which is Parsons. You're recorded here. So in the middle of the project, Parsons losing their staff. So we as a prime and also Paul as a client was getting concerned. So we explored the option to remove Parsons and replace it with another firm. So that gets into the contract termination clause. So we managed to negotiate the first set of it. Now we're going through a second phase of that, remove them completely from the contract because of continuity of the same issues. Now, since they're going to be all off the contract, they are, you know, kind of playing hardball with us, kind of thing. So they want to get paid whatever they have done, and we didn't really. In the previous process, they actually overbilled us and we actually paid them. The overbid from the sense of some task has budget authorized to them, but they didn't work on it. They work on, like say, first task number 1, but they blow over task number 1's budget. So they're actually advanced task number 2, but nothing was done task number 2. Overall limit is still within the budget, but really, if you look at it from individual task standpoint, they're over. So we pass along, we build the poor that didn't really realize that we got paid, we pass along, pay the person. Now everything comes to the wall, everyone's looking at details. And we found ourselves, there's a bigger hole in the budget, And the person says, hey, I got paid, you got paid, I got paid, what's the problem? I did additional work of this much, I want to get all of that paid. So they want to get paid on both sides. If they did get paid on both sides, we have this big hole that we have to hold back for. So how that relates to what we talk about? Yeah, I think it's like a payment.
Or risk management.
Risk management, yeah. So that relates partially to contract, partially to project management, I think partially to payment clause. So I think the right way to do that is have a earned value calculations every month, and insist on subs to do that every month. On this particular case,
At least some written explanation of what they did
yeah.
that justifies.
In this case, they didn't bill us for like 6 months in a row, and they hit us a bill. That's kind of how everything comes together. So we're going through that process right now, trying to, come to agreement how much we're gonna have to pay Parsons for them to be relieved from the contract. Another part of that is relieving the consultant is sometimes it's actually a detrimental thing for a prime, because you don't want to easily relieve a sub-consultant from the contract to relieve their liability. So whenever we get into that situation, we need to think twice, and is that's the best thing for everybody to do. What's the lessons on those Terminal Island 1? I mean, I think all the details kind of matters. Going through the details and every step, eventually is it come bite you in the back from a contractual standpoint. Because for a small company like us, we really can't get into the court. So they have their own in-house attorneys, and every time you face with attorneys, we have to pay a lot of attorney's fees. We just simply can't afford that. Anything you want to share?
No, I think that's probably enough, huh? I already talked about the expert witness stuff.
Yeah.
So.
You guys have anything you want to share, talk about?
So we have to have a termination clause under those sub-consultants agreement.
Yeah, we do have that.
Contract.
Yeah, we do have that, but it's a fairly standard, general statement. We have a right to terminate. The work they've done can get paid. I think it boils down to the details.
Right.
How those numbers and scope is determined, and that's where it getting a little bit hairy.
And the liability, because if they didn't finish the design, they're not.
Right.
You didn't give me a chance to finish. I can't be liable.
Yeah.
The new guy coming in wants to get paid extra
liability,
to make sure everything that was done is okay.
Yep.
So it's tough.
Are there
Hopefully that doesn't happen.
do you have boilerplate agreements?
For termination?
No, just in general sub-consultant agreements, because I know.
Yes, we do.
Sub-consultants.
Yeah, we
It's
do.
the same.
Yeah. Yeah.
Yeah.
We're done, Ben.
I was working with this network change order
Okay.
with Hanko Exos.
Oh, okay.
Okay. Yeah, we just spoke about it. If not, we can just adjourn. I mean, get this and wrapped up, so we can. I think we learned a lot from this morning.